everyone, my name is Stacia Pius. So today I'm going to talk about the case study and the answer for the question that given. I've read the question and the situation. So the issue is whether Sandra, who is a minor, can be in a partnership with Melvin that is a majority. It is because Sandra was 16 years old and that means she is a minor.
Hi, Assalamualaikum. My name is NurAisyah Binti Awang Khairudin. I am from DPM3 Session 1, study at Pillay, Sarawak. So today I will talk about agency sales of group regarding our business law assessment. Okay, I will explain the most suitable type of agency with elaboration. The first one is ratification by the principal. Agency by ratification can arise in any one of the following situations, like an agent who was duly appointed and exceeded his authority, or a person who has no authority to act acted as he has authority. When one of the above said situation arise, the principal can either reject the concept or accept the contract so made. When the principal accepts and confirms such a contract, the acceptance is called ratification. Ratification may be expressed or implied. The effect of ratification is to render the contract as binding on the principal as if the agent had been properly authorized beforehand. Okay, the last one is the duties of an agent to his principal is to obey principal's instruction, to exercise care and diligence in carrying out his work and use such skill as he possesses, to render proper accounts when required, to pay to his principal all sum received on his behalf, to communicate with the principal, not to let his own interest conflict with his duty, not to make and seek profit out of the performance of his duty. Next is to not to disclose confidential information or document. And the last one is not to delegate his authority.
The next question is I have to explain the conclusion based on the issue. So the issue is whether Sandra, who is a minor, can be in a partnership with Melvin that is a majority. Generally, there can be a partnership between a minor and adult. A minor could be in a partnership for any duration of time until he or she wanted to disfirm it, according to Gord B. Harrison, 1821. However, there is a certain things a minor don't need to do, such as a minor cannot incur or be responsible for any contractual liability for the firm's debt. On reaching the age of majority, a minor can, if he or she wish, discharge themselves from all future debts of the firm by terminating the partnership. Failure to repudiate the agreement will make him or she liable for the partner. In this case, it established that although a minor can be a partnership and be entitled to share in the profits of a firm, he or she cannot personally be sued for the firm debts incurred by the minor on behalf of the firm. The adult partner are, however, entitled to have any capital contributed by the minor apply in satisfaction of the firm debt and to deduct any losses from his own drawn or future share of the profit. However, can apply his or her capital contribution and can deduct losses from his or her shares of profits. Before the age of 18, A minor may repudiate the partnership but once reached an age, if not repudiate, will automatically become a full partner but still will not be liable for debt incurred during infancy. Now I'm going to explain about the maxim caveat emptor principle with relevant provision. First of all, what is caveat emptor? In a Latin press, it translated as "let the buyer beware." The press described the concept in contract law that places the burden of due diligence on buyer of goods or services. Caveat emptor is a fundamental principle in commerce and contractual relationship between a buyer and a seller. According to a caveat emptor principle, a buyer is responsible for performing the necessary due diligence before the purchasing to ensure that a good is not defective and that it suits his or her necessary action. He or she will not be entitled to any remedies for damage in case the purchased product shows significant defect. Although the caveat emptor principle can be applied to the purchase of any goods or services, nowadays it is primarily applied to real estate transactions. Most consumer goods transactions in different jurisdictions are regulated by specifically designed acts, while the caveat emptor principle is losing its significance. In addition, the financial services industry is a major exception from the caveat emptor principle. Regulator requires sellers of financial products to disclose as much information as possible to the buyer. Generally, the seller of a financial product is required to provide relevant information about the product in a standard form. The caveat emptor principle does not apply when the seller provides false information to the buyer or when there is misrepresentation of the products. For an example is Agnes purchased a house from Monica. Before the purchase, Agnes asked the seller about the defects in the house. Monica told her that there was a leak in a bathroom upstairs, but it was fixed already. However, Monica also warned Agnes that despite the repairs, a small leak could occur from time to time. Agnes failed to inspect the bathroom properly, but still decided to buy the house. After 3 months, there was a big leak that damaged the floor in the bathroom and the ceiling in the dining room downstairs. Agnes decided to go to the court to recover damage from Monica. However, the judge states that Agnes is not entitled to any remedy because the caveat emptor principle is applied. Agnes did not perform due diligence to ensure that the defect in the bathroom could not cause any damage in the future.
Hello everyone, my name is Adriana, Raphael, Ramesh, Pillay, and today I'm going to explain the expectation available on the maxim of caveat emptor principle with the situation above. Good must be reasonable fit for purpose of which the buyers want them, where the buyer expressly or indirectly make known to the seller the particular purpose of which the goods are required, so as to show that he or she relies on the seller's skill or judgment, and the goods are of a description which is in the course of the seller's business, to supply the implied condition that his goods shall be reasonable fit for such purpose. But in the case of a contract of a sale for a specific article under its patent or other trade name, there is no implied condition as to fitness for any particular purpose. Of course, the buyer would not tell the seller the purpose of the goods in the obvious case, such in Punca Niaga v. NZ Wheels in 2012, 1 MLJ 27. Even when goods may have only one obvious use, if the goods are required for a special purpose, the buyer must explicitly notify the seller of the purpose and rely on the seller to prove him with a suitable article.